Tip number 2, legal tip number 2, is to have your trademark attorney do a trademark availability search for your project name. So we talked about how your project name is a potential trademark, but before you pick that name, you should have your trademark attorney do a trademark availability search. If there is something similar that already exists out there, the person who was first wins. And it doesn't have to be identical to what you're doing. If a similar project name or something in the tech market or the blockchain market or a different type of token or something that is just in a different market that is significantly similar to your project name, such that it's likely to cause consumer confusion as to source and origin, then whoever uses it first wins, which means a pre-existing mark owner can shut you down. It can take your domain name if your domain name matches your project name, and you could become legally liable to all your NFT buyers because you were unable to pass the rights on to them that they were expecting, because potentially your store gets shut down on OpenSea and potentially you have to literally go out of business. So you're taking on liability if you pick a trademark, a store name that's going to be confusing, similar to someone else's store name. You want to make sure that you do the availability search. It's a very sophisticated phonetic search with word swaps and letter swaps. A trademark attorney is going to get that search report back and is going to analyze it and is going to tell you which pre-existing marks may be problematic for your company. So the goal here is you don't want to infringe someone else's pre-existing rights and get a threat letter, trademark infringement threat letter that says you must cease and desist, right? But also you want to build brand value, and you can only build brand value by creating a unique brand name that can only be you. So pick something unique, and then of course if you do pick something unique, you're going to be able to protect your mark against imitators, fraudsters, and copycats. Ready for tip number 3? Tip number 3 is following right in line. Make sure you register your trademark with the USPTO. You don't have to register your trademark in order to have trademark rights, but if you do, special things are going to happen. All right? So you want to, if you do your trademark availability search and it comes back clean, that trademark attorney is going to tell you that you have a high likelihood of getting it registered with the USPTO. So you want to go through that process. And one of the reasons is you can file an intent to use registration before you even use the name. So remember I told you a minute ago that whoever was the first to use it in commerce wins. They have priority. There's one exception to that, and that's if you file with the USPTO an intent to use registration where you're putting your marker down saying, even though I'm not in commerce yet, even though I haven't launched yet, I'm claiming this project name, this brand as mine. And so you can jumpstart that priority date by filing an intent to use registration, which is really important because if you know your name and it's clear, it may take you months to launch. You want to get an intent to use registration in place so that you don't lose your priority rights. If you achieve registration, you also get certain presumptions of validity and boom, up to $100,000 in statutory damages and attorney's fees that you can threaten against any infringers. So if I send a threat letter out for trademark infringement on a common law mark where I don't get the presumptions and I don't get the statutory damage benefits, right? The other attorney knows I have to prove my damages. And that can be really hard in a trademark context. That's why the Congress passed a law which gives you penalty statutory damages even if you can't prove any damages. This is a big stick against infringers. So this is going to make for a really powerful threat letter if you have a registered trademark. All right. So why do you get trademark registration? Because you get super rights and super presumptions and statutory damages. That, my friends, is tip number 3. Here is an example which we'll be doing a deep dive into in one of the next videos on tip number 3, where the Bored Ape Yacht Club, very famous NFT drop, They dropped in May of last year, unexpectedly went through the roof, now worth tens of millions, hundreds of millions of dollars, who knows, right? But they did not register their trademarks prior to launch. In fact, these are just serial numbers here. This is registration numbers here. They haven't made it through the registration process on their marks. They're just filed. They're trying to get through the process. Why? Because all these other NFT projects copied Bored Ape Yacht Club, something else Yacht Club, something else Ape, and arguably infringed the Bored Ape Yacht Club's various trademarks, causing consumer confusion. Of course they were. That was what their goal was, to draft off all the goodwill of Bored Ape Yacht Club for their copycat project. So Bored Ape eventually got a lawyer, and they are going through the registration process, trying to get some of their marks. These are all variations of trademarks that they use for their NFT drop, trying to get those registered so they can get some real leverage on their threat letters. And you can see here's an example of one of their filed marks for just the words Bored Ape. And you can see downloadable game software. There's lots of different things that you can register for. Non-fungible tokens used with blockchain technology. They're trying to get the verbiage down with the USPTO on this. And the USPTO is trying to figure out what a non-fungible token is, so you need a good lawyer to help you get through the registration process. Virtual goods. These are the categories of goods and services that they're going to be protected in. All right, so enough about tip number 3 in trademark registration. We're going to revisit that another time.